Thank you, everyone, for joining us for another book symposium that the Technology, Innovation, and Intellectual Property program at the Classical Liberal Institute does as fantastic monographs on copyright patents and other aspects of intellectual property and innovation policy are published. We enjoy having opportunities to engage with the authors and have commentary on their work. My name is Adam Mossoff. I am co-chair of the Technology, Innovation, and Intellectual Property program at the Classical Liberal Institute, along with my co-chair, Bo Hayden. And we are delighted to today to be having Dr. Porna Masur talk about her new book, Copyright as Personal Property. It is a tremendous and monumental work in jurisprudence and in doctrine, interweaving beautifully how property theory and conceptual property theory and animates and explains and justifies the doctrines within copyright, both how we obtain and receive and enforce copyrights, but also the limits on copyrights. The program today will begin with a presentation by Dr. Mysore on her monograph, and then we will have commentary from three professors and experts in copyright law and policy, starting first with Professor Lauren Mulrain, being followed by Professor Gerardo Con-Diaz, and then last but certainly not least, Professor Henry Smith. So without further ado, I'd like to now turn it over to Dr. Mysore to give us an overview of her work. So Dr. Mysore, take it away.
Thank you, Adam. Thank you, Bo, and thank you, Richard, for this invitation. It's a tremendous opportunity for me to present my work to such an august audience and to be able to learn from you all. I think there's really nothing better than to get such an amazing group of experts give me some feedback on my work and give me ideas for my future research as well. I can't wait to get involved in this discussion. I thought because you've all had an opportunity to just skim through my book, I thought I will take this opportunity more to say something about what prompted me and what inspired me, what drove me to write this book, more so than actually going over a kind of a summary, if you will, of my book. So I thought I'll give you a bit of the background, which will hopefully explain why the book has gone in the kind of direction that it has. So in this part of the world, I mean, in the UK, property theory is pretty much engaged with by those who look at property as a tangible asset. So intellectual property scholars engage largely in doctrinal research, and when they are not doing doctrine, they will probably do a little bit of history, and when they're not doing history, they um, probably engage in a little bit of interdisciplinarity. And of course, that is a very, very worthy way of engaging with the discipline. But what I had seen, um, a kind of a big gap in the research is intellectual property scholars themselves doing some amount of property theory coming from where they come from, i.e., talking about the conceptualization of intangible property, intangible asset, how that interacts with the system of tangible assets. There isn't a whole lot written by intellectual property scholars. There is some amount of it. There has been some amount of it in the 20th century and at the turn of the century into 21st, but there isn't a whole lot that's been written about it. And property theory as such is written in the context of UK doctrine by those who write on land law or personal property law, but very much of a focus on tangible assets. And when they do engage in anything that's intangible, especially intellectual property, they would treat that as something else. It's different, it's statutory, it's not something that we need to be really concerned about. So, property theory, the front and center of it was um, entirely captured by land law scholars and personal property scholars. Personal property, I mean tangible personal property scholars. So, and the way those scholars would deal with intellectual property was something that I found came from a place of not having the understanding of doctrine, first of all, and sometimes possibly also having a little bit of misunderstanding of what intellectual property is as a broad concept. And of course, as they drill down a bit deeper, some of the even graver misconceptions became apparent to me. So I thought something needed to be done to fill that gap. We need a voice of the scholars coming from intellectual property side of things and deal with property theory from that perspective. The other set of theorists who have written about property theory, they tend to come from the perspective of commercial law in this part of the world. And for them, anything that's transferable is property, and therefore it doesn't really matter how the intangible asset is conceptualized. For them, tangible assets are different, intangible assets are different, and those are the only two categories that exist. And we really don't need to think about the nuances of how each intangible asset is different, so long as they're all transferable and we have got laws that govern the transferability. That's all that really matters. I mean, you can see that when you're coming to it from the perspective of a commercial transaction, that's what you will be really interested in. So it's a very instrumental way of looking at what the theory can do in understanding intangible assets. So that is, again, a little in a way, a narrow perspective, a perspective that just serves the purposes of that particular area of law. So, as such, what we have in this part of the world is this sort of bipolar understanding of property rights. On one end, you have those who talk about tangible property as the front and center of everything, and you have the conceptualization of property that cannot be different from what is presented by the tangible assets. And at the other end, you have the commercial lawyers who say that these are all shows us in action. You will have seen me engage with that terminology a lot in my first couple of chapters. So you have shows us in possession, all the tangibles, and shows us in action. So put all intangibles in this one box, shows us in action, and we really don't need to do anything else. And that bipolar classification is pretty good. That's how far we're going to go with engaging with property theory. So, and of course, this is obviously on the face of it, it's quite clear that this is an incomplete, unsatisfactory way of understanding the whole diversity of intangible assets that there are. And it's in a way a blinkered way of looking at intangible assets as well. So I thought there was a need for there to be a better conceptualization of this. And then, of course, on came along our Law Commission report, which you will have also seen me referring to in my book as well. So, Law Commission on digital assets started talking about the third thing. Of course, you have two ends of you have two binary sort of assets, you have tangibles, you have intangibles, so shows us in possession and shows us in action. Of course, there is a third category that we need to have, and of course, they were coming from the Law Commission, which did this whole review of this area. They were coming to it from trying to understand whether digital assets such as crypto assets or non-fungible tokens and assets of that kind, whether they can be treated as property. And they had also a particular agenda. When you look at the Law Commission report, you know that they are being instrumental about achieving particular political goals. And of course, it was a document that was going to inform, and that has in many ways informed the way the law reform was going to happen. New statute was going to be introduced in relation to the digital assets. So they needed to talk about something that is new, something that's different. So talking about it as a third category and something really new and something really exciting really helped that agenda in a way. But really, I wasn't convinced at all that it's only now that we have started thinking about this third category. Digital assets, of course, as revolutionary as they might be in terms of technology, I didn't really think that as assets, they are introducing this third category and that this third category is something new that didn't exist before. And only now, for the first time, um, theorists and scholars are having to address their mind to this new third category of things. So I didn't think that it was that new. To me, already intellectual property rights in their own evolution, in their own historical evolution, had already started thinking about intangible assets, intangible property, and the whole evolution of property rights in a way that had already challenged the the binary classification of shows us in possession and shows us in action. So almost about 150, 200 years ago, this debate had started emerging. Um, that it's not just two categories of assets that we have. We also have this third category, which is all sorts of intellectual property law, which was coming into prominence in those days, new statutes being introduced. So the whole debate around new way of understanding property rights had already happened so long back. And now for us to think about digital assets as introducing this new debate didn't seem like all that new. And of course, in the Law Commission report, the report does engage with intellectual property, and they have one chapter which addresses intellectual property just to acknowledge that it does exist. But the brevity with which it was dealt with and the kind of blinkered vision that it gave intellectual property assets and how sort of quickly they brushed aside, oh, you don't really need to think about intellectual property rights because they relate to non-rival assets and therefore they're very different. We are talking about something more rivalrous, and therefore this is the reason why digital assets are the third category, and intellectual property rights you don't really need to pay much attention to. So of course they would say that they didn't want to really engage with intellectual property rights. It wasn't the agenda. It wasn't part of what they were going to do in the Law Commission report. But then that left everybody thinking that intellectual property rights, we don't know how to classify. Let's just forget about it. Let's think about digital assets. You know, the kind of resurgence in this whole conceptualization of intangible assets, but one that is informed by how the Law Commission wanted them to think about it. I thought this would lead the whole debate into a direction which will retain the binary classification, but in a way complicated by introducing a third category, which isn't really a third category, but completely misalign the whole classification in that way. So I thought there needed to be something that talks about intellectual property rights and finds a place for intellectual property rights within this larger debate, within this binary classification, and within this third category having been introduced by the Law Commission. So we needed to find a place for the IP rights. That's at least what my agenda was. So I didn't want to do it as a intellectual property rights as a broad category. And of course, there are two reasons for that. One very immediate reason is I'm more comfortable with copyright than any other form of intellectual property. So it was just very much easier for me to write about copyright. I also happen to um, really adore this area of law. I wouldn't use the word adore, but I do. I think as far as intellectual property rights go, copyright is something that I feel so closely connected with that I thought it would make me write more authentically if I just focused on copyright. I had the level of comfort in its doctrine as well in this part of the world, having written my first book on copyright as well. So I thought taking copyright as an example of intellectual property rights, it would make sense for me to think about where we can locate copyright in this world of different kinds of assets, some tangible, some intangible, and then see how we can draw this picture. We can sort of redraw this picture and arrive at something that might be a little bit more coherent than what exists today. So this was a kind of an effort at taxonomy to start off with. But I couldn't just write a book on taxonomy. Of course, as much as we like coherence, and we as academics probably love nothing more than having this a very beautifully expressed, coherent area of law. But in addition to that, it had to achieve some purpose. And what would that purpose be? The other thing that I have seen in this part of the world, especially in Europe, um, and to some extent in the UK as well, is that property has bad reputation. Property means expansion. Property means usurping what rightfully belongs to the public, but this exclusivity is somehow treated as anathema to progress. And the property as an idea, when it is associated with intellectual property and particularly with copyright, has um, this sort of very easy um, run into expansionism. And so copyright's expansion is blamed on the fact that it is conceptualized as a property right. So I wanted to show the limiting function of property much more so than its expansive idea of its expansive attributes. In many ways, I mean, I do strongly believe that property is very much about defining boundaries. And when you define the boundaries, it is as much about limiting for you as a property owner as it is for the rest of the world, for them to understand where the boundaries lie, and for you to know that you can't enforce beyond those particular boundaries. So it's a kind of it cuts both ways, and one needs to appreciate the fact that that is the objective of defining something as a property right. And more so for intangibles than tangibles, I thought it was essential to establish that understanding something as property means that boundaries are clearer, and this is how we get to the property playing the limiting role, and be able to maximize that within our doctrine. So that was an additional objective I wanted to achieve, and I thought it needed to be shown more so in copyright than any other form of intellectual property. So those were the two sort of driving ideas which made me write the book. And of course, it was, as you would know, with all writing of books, it's a labor of love, and you just do nothing but write until you get to the last page, and it's a very difficult job to let it go and let it speak to the world. So you want to sit on it, you want to think about it, you want to reform it, reframe it as much as possible. But finally, I felt ready for it to go and speak to the world. I wanted it to be a sustained piece. I wanted it to be a something that would capture pretty much the whole life cycle of a a copyright work. Um, I could have published it as individual articles, but I thought it would make sense for it to be a monograph for all ideas to come together and for this for the direction I want intangible assets to be conceptualized in, for that whole idea to be crystallized in a monograph much more so than in a series of articles. And that was the purpose behind putting it together in a monograph. And one last thing, the reason for it to be a monograph is also that when I first started thinking about what is intangible thing, can we think about the thinghood of intangibles? Can we think of intangibles, at least some of the intangible assets, where we can separate the thing from the right itself? And what would that look like? Whether we can do it successfully in copyright. Of course, I didn't answer the question whether we can do the same thing for other forms of intellectual property, such as patents and trademarks and others. But with copyright, if we were to do it, where would we take that argument to? So when the conceptualization of thinghood started crystallizing in my mind, I realized that so many things that we think of as consequence of something being a property right arises from the fact that it started as a thing. It started as a right in association or relating to the thing. So when that is the case, then starting with the thing, you can actually develop the rest of the consequences of the thinghood in a way that kind of keeps connecting back to what your idea of thing is. And that's how, when I started building over the idea of thinghood, it looked like I had a monograph in front of me. So there was no other way to express it than as a sustained full length monograph. So there we have it. So that's how it came to be written the way it's been written. And I'm really eager to hear your comments and your critique on what I have written. So I'll stop there. Um, Over to you, Adam. Yeah, take
Yes.
it away. Yeah, thank you.
Thank you, Purna. It is a very elegant and fantastic work. I enjoyed reading it tremendously. So and I too am looking forward to hearing the comments. So kicking us off with the as commentator is Professor Lauren Moraine from Belmont University. Lauren, can you just you can just take it away from here.
All right. Thank you, Adam, and thank you, Professor, for this work. I will say that while reading it, it certainly inspired me, it gifted me with some ideas for some future scholarship. So, in that regard, you've already done your job. So, again, thank you for this opportunity to be part of the program. The beauty of being on a panel like this or a symposium like this one is hearing the discussion of scholarly works from the varied and disparate perspectives of the participants. So the starting point for me has always been looking at intellectual property from the perspective of being a songwriter and a singer and a musician, as well as a person of color. So yes, I am a law professor and a lawyer, but I try to never lose sight of how the law in its form and in its application affects people who look like me or create as I do. So this is where my perspective comes from, just to kind of give you an angle on that. So I'll spend a few minutes, the next 15 or 20 minutes, talking about some of these ideas. So under U.S. law, copyright is generally treated as a form of personal property, with the basic stew, as it were, sitting at the intersection of property theory, statutory design, and constitutional purpose. Our constitutional purpose is birthed from the mandate that Congress shall have the power to enact laws that promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. We've come to view these statutes, including 17 U.S.C., which governs copyrights, as providing a limited monopoly for creators such that they will be actuated to be as prolific as their talents allow, thus enriching the public that naturally benefits from the proliferation of original works of authorship. 17 U.S.C. 106 provides that copyright owners, typically the original author, get a set of exclusive rights, including the right to make copies, distribute, make derivative works, perform and display publicly, and distribute by means of a digital audio transmission. This is analogous to the rights entitled restricted acts under the UK's Copyright Design and Patents Act of 1988, or the CDPA. In chapter 1 of the work on page 54, Professor Mysore mentions that the statute makes the requirements of a work having to acquire form constitutive of copyright arising in relation to it. This is analogous to the U.S. statute granting copyright to works that are fixed in a tangible medium of expression. And the distinction made between authorial works and entrepreneurial works bear some similarities with how we treat music copyright, i.e., two separate copyrights, one in the underlying song and any number of additional copyrights in the sound recordings that might be made of that song. Professor Mysore notes on page 65 that the insistence on separability of the subject matter helps leave ideas free. And this leaves the building blocks of creation available in plenty to foster greater creativity and promote diverse works based on the same idea. In the US, we refer to this as the idea expression dichotomy. Ideas can be copyrighted, but original expressions cannot be copyrighted, but original expressions of these ideas are copyrightable. So I saw those parallels, different terminology in UK law, but covering the similar things that we talk about here. In chapter 3, Professor Mysore tackles the topic of acquisition and copyright. And she notes that if the thing is tangible, then property rights in it can be acquired by taking possession. If the thing is intangible, property rights can still be acquired by other means prescribed by law. Professor Mysore continues, the upshot is that the preoccupation with the physical in the conceptualization of possession should not make us blind to the possibility that there are rules of acquisition also of intangible things. I'm particularly attracted to this line of legal analysis as it relates to both creatives, for example, songwriters and recording artists, as well as how it relates to traditionally marginalized communities. Over the last 70 or 80 years, we have been conditioned to recognize recorded music as a physical object produced and promoted by commercial recording companies. In fact, when I was a kid, I remember how I connected what the music would sound like to the actual label that was on the albums or the 45s that my sister and I would purchase. You knew what you would expect or what you should expect when you put on one of those records with the red Atlantic Records label on it, or the blue Motown, or the green Philadelphia International Records label. This expectation actually created a conditioned mind where obviously the record you're listening to is owned by the name that's emblazoned on the label, right? After all, the artist's name was so much smaller, so much smaller font, not to mention the names of the songwriters and producers. While copyright scholarship has always considered the labor theory of Locke, as Professor Mysore says on page 77, for some reason, when it came to recorded music, along with other manifestations of intellectual property such as films or books, creators were always subjugated to giving up their rights in order to have corporate entities manufacture and promote their works. This ill-fitting reality is due in part to the balance of how we identify the rights associated with the intangible works of the mind and the tangible chattels upon which they reside, such as records, books, or films. As Professor Mysore shares on page 79, in the copyright context, what exists before the work is created are the ideas, the material in the public domain, the language, the rules of grammar, musical notes, and so on. And indeed, everything that inspires, drives, or even just supports human beings to create a product of their mind. But as it were, commerce would have us believe that the corporate entities that serve to bring the product to market should have the lion's share of the ownership and financial benefit from the exploitation of the works. I would suggest that this is due in significant part to the uniqueness of copyright being a product of intellectual and intangible property. We just typically we don't see it the same. as you would a fence around a yard. As Professor Mysore states on page 81 in her discussion of exclusionary rights, in relation to tangible things, the exclusionary signal is an important aspect of control in that only the person exercising physical control should be able to use and enjoy the thing. She continues, in relation to tangible things that can be brought within a person's grasp, the act of grasping, together with the boundaries of the physical thing itself, send a signal to the rest of the world that they must excuse themselves from interfering with those boundaries. I was intrigued by Professor Mysore's explanation of the exclusionary signaling in copyright and how, under the concept of the rule of capture, under the scholarship of Oliar and Stern, naturally applies to copyright because of the fixation requirement under U.S. law. But while it's absolutely true that a person is not deemed the author of a work by recording it, in practice and under the contractual traditions of the entertainment industry, this is essentially the price that creators pay when they enter into contractual relationships with record companies or film companies, sometimes with book publishers. Because of this, when we see the flexing of rights attached to exclusion from certain courses of conduct, we traditionally see those rights being flexed by corporate entities more so than creators, further cementing in the mind of the public that the owners of these properties are the corporate entities. For their part, music fans recognize public performances by their favorite artists as belonging to the artist. As Professor Mysore states on page 85, expressing a work is the exclusionary signal that a person sends out to the rest of the world to alter their conduct in relation to the work. The author conveys to the rest of the world that she is staking a claim to the new thing that is coming into existence by such expression. In a live concert, that expression is the performance. But as we heard over and over during the early 2000s, as Napster, Grokster, and LimeWire disrupted the music industry, many fans never felt as though they were taking from the artist by redistributing the artist's recordings. Notice I said redistributing because as an artist, I can't bring myself to call this act file sharing. How can you share something that's mine without my permission, right? But fans didn't see how they were depriving artists of any rights by downloading files for free. After all, they weren't taking anything from the artist's home or from their hands, were they? That really ties into the discussion, Professor Mysore's discussion on non-rivalrous rights, right? They didn't see this as them taking something out of your hand, and so I can't really be doing anything wrong. I strongly relate to the section entitled From Work to Copyright Work on page 86, as Professor Mysore compares tangible and intangible things and how they are created. Specifically, neither tangible goods nor intangible works exist in their new state before they are manufactured in the case of goods, or composed in the case of musical or other copyrighted works. Chapter 3 draws to a close as it asks the question, even if one can argue that a work is the thing in copyright, how does one make a work one's own? This push and pull between the tangible and intangible, coupled with the nature of entertainment industry capitalism, typically has the greatest negative impact on creators, many of whom come from modest means, while granting outsized benefits to corporate entities who benefit from the modified golden rule of he who has the gold makes the rule. Chapter 4 asks the interesting question, is copyright a property right in the thing or in the monopoly over the thing? In my analysis of how copyright applies to creators and communities of color, it often doesn't matter because of the contractual agreements to which artists and creators have historically agreed. But I do agree that the exclusionary rights in copyright bears a close resemblance to the exclusionary rights to tangible things, which Professor Mysore speaks of on page 121. And it is reasonable to conceptualize copyright as rights in a monopoly over the thing. This dovetails with the exclusionary language of copyright statutes, which give authors the exclusive rights against the world for the use, distribution, and performance of the copyrighted works. Chapter 4 concludes with a reminder that exclusionary rights, exclusive powers, and exclusive privileges are all major components of copyright ownership, and furthermore, these exclusionary duties in copyright are not so divergent from the duties imposed in relation to tangible things. That was a very, very strong point, I thought. As I read Chapter 5, Copyright Enforcement and Remedies, I found myself comparing vindicatio, the remedy enabling a claimant to take back the thing itself, with our statutory rights of copyright termination. Of course, even with these statutory rights, U.S. record companies are leaving no stone unturned in their efforts to thwart the rights of artists to terminate copyright transfers at the statutorily prescribed time period. Yes, this is a little different discussion than the one regarding enforcing copyright against infringers who are utilizing the works without permission of the copyright owner. But at the end of the day, the ramifications upon the authors can be substantially similar. I wrote a piece a few years ago calling for revised language of the termination portion of the copyright statute so that artists and authors would not be foreclosed from their termination rights after the 5-year window. In my opinion, the current language is unnecessarily punitive and disproportionately affects creators who are not educated on the vagaries of the statute. This often means creators of color who may not have connections to industry experts and legal counsel with expert in this very specific area of the law. There is, however, a recent copyright termination case that speaks directly to this topic of copyright as personal property. And as I was preparing my comments on this wonderful monograph, I saw this case and thought that it would be a good thing to talk about in the midst of this. Section 203 of the Copyright Act was designed as a paternalistic pro-author mechanism. Under the statute, authors cannot contract away termination rights in advance, even if they want to. The right is inalienable and personal to the author and certain heirs. In the recent case, Lil Joe Records, Inc. versus Christopher Wan Jr. et al., 3 of the 4 members of the band 2 Live Crew filed a copyright termination to recapture rights to 5 albums. The district court concluded that the termination interests of 2 Live Crew member Mark Ross were excluded from his Chapter 7 bankruptcy proceedings and thus could be part of the termination. However, the 11th Circuit Court held that despite termination interests being inalienable by agreement under the Copyright Act, Ross's interests became part of his bankruptcy estate and were held as property of that estate at the time he purported to exercise them. Judge Brasher said that Section 541 of the Bankruptcy Code had swept Ross's termination interests into his bankruptcy estate before he invoked them, because he held them as interests in property when he filed for bankruptcy. Without Ross, a majority of 2 Live Crew was not able to exercise the termination right because only 2 of the 4 members were asking for the termination. The lower court had interpreted Section 203 of the Copyright Act and Section 541 of the Bankruptcy Code to exclude Ross's termination interests from his bankruptcy estate. The 11th Circuit said that this appeal presents a question of first impression at the intersection of copyright and bankruptcy. Ultimately, the court expressly rejected the notion that copyright law's anti-alienation principles kept the interest outside the bankruptcy estate. This case poses a challenge to both extremes of the copyright property debate, the traditional property view and the author protective view. Under the traditional property view, the strongest property theorists argue, 1, copyright is property; 2, property interests should generally be transferable, descendable, and subject to creditor claims; and 3, bankruptcy law should treat copyright interests similarly to other valuable assets. The 11th Circuit's reasoning strongly supports this conception. The court effectively said if a termination interest has economic value and constitutes a legal interest held by the debtor, bankruptcy law sweeps it into the estate unless Congress clearly says otherwise. This sounds very much like ordinary property law. Under the author protective view, scholars frequently argue that termination rights are not merely property rights, but are instead a statutory second chance, a moral entitlement, and author-centered protection against unequal bargaining power. Under this theory, allowing creditors or bankruptcy trustees to control termination rights undermines Congress's purpose. The district court victory for Two Live Crew was easier to reconcile with this perspective because it preserved the artist's ability to reclaim their copyrights decades later. The 11th Circuit's reversal suggests that bankruptcy policy may sometimes override the author protective purposes of termination law. This case is a modern illustration of Professor Mysore's central inquiry. What does it really mean to call copyright property? The Two Live Crew case demonstrates that copyright interests can simultaneously be personal rights created to protect authors and property rights that become available to creditors in bankruptcy. This decision reveals that copyright status as property is not merely rhetorical. It carries concrete consequences in other legal regimes. The more copyright resembles property, the more vulnerable it becomes to doctrines developed outside of copyright law. Bankruptcy is the perfect example. The case suggests that the real debate may not be limited to whether copyright is property. It may, in fact, be which body of law gets to define the incidence of copyright ownership. Is copyright ownership defined primarily by copyright law's author protective objectives or by the broader property framework of bankruptcy, inheritance, secure transactions, and creditor rights? The 11th Circuit's answer appears to be that once a copyright-related interest qualifies as property, other property systems have a claim on it too. This is precisely the sort of cross-doctrinal problem that sits at the heart of the copyright as personal property debate and literature. Professor Mysore's discussion of copyright infringement and trespass in Chapter 5 reminds us that accessibility to the public does not necessarily mean the work has been observed by the defendant. This also triggers a reminder that we are in a new era now with regard to defining wide dissemination. Of course, I don't have time to talk about that in this discussion, but we certainly should be on the lookout for that. U.S. law answers the copyright as personal property question in a qualified way. Copyright is personal property, but it is a uniquely statutory and policy-shaped form of personal property. Yes, copyright is treated as intangible property that may be owned, transferred, inherited, and commercially exploited, but it is not property in an absolute common law sense. Instead, copyright is federally created, constitutionally instrumental, time-limited, divisible, burdened by public interest limitations, and partially insulated from unrestricted alienation through doctrines like termination rights. I will conclude my comments by saying that in the U.S., although copyright is called property, courts repeatedly have emphasized that it is a creature of federal statute rather than a natural or absolute property right. These rights are time-limited, divisible, subject to statutory exceptions, and conditioned by federal policy goals. The consistent judicial message has been copyright is property, but only the property Congress created. Unlike ownership of a car or land, copyright exists only because federal law creates it and defines its limits. Thank you.
Thank you, Lauren. That was fantastic comments, and really appreciate the engagement with Poorna's work. We will now hear comments from Professor Gerardo Con-Diaz from the University of California, Davis. So, Con, take it away.
Thanks, Adam. Hi, everyone. I'm Con, and I'd like to thank Adam, Bo, and Richard for having me, and Poorna for sharing this fabulous work with us. I'm very sorry I'll have to leave during our break for a meeting. I'm department chair, and our quarter is still going. It just won't end. So let me tell you a little about what I do so that you have a sense of the sorts of questions and methods that tend to draw my attention. So, Science and Technology Studies, that's my department, or STS, is often misunderstood as the study of science and technology. But really, what it is the study of how knowledge, institutions, material practices, and systems of governance become durable enough to organize collective life. And so, our field welcomes scholars from all disciplines, including lawyers. And what unites us is a common concern with the processes through which objects become knowable, categories become authoritative, and institutions produce forms of order that eventually come to appear as neutral or as inevitable. That perspective has always placed STS in close conversation with law, and that's where I've spent most of my career so far. And when we think of law, we think of how it helps to create the categories, objects, relationships, and the forms of authority that make governance possible. We think of how much of its work involves transforming uncertainty into stability, ambiguity into recognizable categories, and contested claims into durable institutional facts. And with that, you can see why I was just so delightfully struck by this book. It hits every single button of the things that draw me to think about law. So, with that in mind, let's just keep going. Let's get going with the commentary. So, the big question animating the manuscript is simple to state, but incredibly difficult to answer. How can we think of copyright in terms of property? And when I encounter that question, I'm far less concerned with whether copyright is, in fact, best understood as or through property than I am with the intellectual work that Purna does by treating it as such. And that question, as I read the book, led me repeatedly towards themes that have occupied STS scholars for many, many years. And what I'll do in this commentary is offer 3 readings of the book. So ways of framing the intellectual work that Purna did in framing copyright as property. So the book can be read as a project, these are the 3 readings, as a project of classification, relocating copyright within a particular conceptual order and exploring the consequences of that move. It can also be read as a study of 2, infrastructure, concerned with the often invisible legal mechanisms that allow works to circulate across markets, institutions, and courts. And 3, it can be read as a study of ordering, examining how legal categories and doctrines reduce uncertainty and create stable expectations among strangers. Read in these ways, the book became to me an inquiry into a problem that extends well beyond copyright. And I was just so delighted to hear Purna say that she saw echoes of this reaching outward. How legal systems transform expression into stable, legible, and governable objects around which rights, obligations, markets, and social relationships can be organized. Okay, so reading number 1. Classification. And here, I'm not thinking about classification in the mundane sense of sorting things into boxes, but instead classification in the deeper sense that has occupied generations of scientists and scholars, determining what kind of thing one is dealing with and what follows from that determination. Purna's reclassification of copyright into property reminded me repeatedly of Jeffrey Bauker and Susan Lee Starr's book, Sorting Things Out. It's one of my favorite books, where they show that classifications help record and organize reality. Once stabilized, classifications shape what can be seen, what can be measured, what relationships appear natural, and what forms of action become possible. And people rarely, if ever, encounter classifications as abstract intellectual constructs. They encounter them instead through their consequences. And seen in this light, the most interesting question that the book raised for me was, what becomes visible once copyright is relocated into a different category? And there are several sub-questions that come out of that. What new analogies become available? What problems become easier to formulate? Which relationships suddenly appear fundamental that previously seemed peripheral? And one answer offered by the book is that copyright's reclassification into property becomes a method of inquiry in its own right. Once copyright is relocated into the category of property, a series of connections that previously appeared contingent begin to appear perhaps even necessary sometimes. Originality becomes a question of acquisition. Infringement becomes a question of interference. Licenses become questions of derivative interests. And the move from IP to just P supplies a framework through which copyright can be known beyond those doctrinal conditions that characterize it today, and as sort of this complex way of reorganizing how we see these connections and these problems. And what strikes me as remarkably powerful in this is that this mode of reasoning, even though the book itself is so novel, the style of reasoning strikes me as so classic, and I mean that as a compliment. Um, and Purna does it in a way that, from my own disciplinary perspective, is an unprecedented scale. So sort of tinker with a classification to see how a bigger structure works. Purna's doing that at a scale that I have never seen, at least from my purview. Across STS, scholars have repeatedly shown how determining what kind of thing one is dealing with is the first step toward determining how it behaves. Classification has often functioned as a source of explanation. Once whales become mammals rather than fish, new questions become possible. And I'm thinking here of Graham Burnett's fantastic book, Trying Leviathan. Once diseases become pathological entities rather than imbalances of humors, different forms of knowledge emerge. I'm thinking here of Charles Rosenberg's work in the 90s conceptualizing illness. And if I may bring myself into this, I think of my own effort to track the legal and commercial grounding of conceptions of the nature of software in my first book, Software Rights. Across these works, the category itself reorganizes the field of inquiry. And something very similar is happening here at the level of a whole field of legal thought in practice. Indeed, much of the book's analytical force derives from the proposition that once copyright is situated within the family of property, certain conclusions become easier to see, analogies become easier to maintain, limits become differently justified, and tensions within copyright doctrine become easier to diagnose. That brings me to a question that I found myself returning to throughout the manuscript. What does it take to make a classificatory move a method of reasoning at this, in my view, unprecedented level and depth? How does identifying what kind of thing copyright is begin to reorganize what can be known about it? And one answer, I think, lies in the fact that classifications are built into the material and institutional arrangements through which a field operates. Categories become powerful when they disappear into the background and begin structuring action. And that brings me to my second reading, infrastructure. For scholars in my field, infrastructure refers to much more than roads, bridges, or other physical systems. We use the term to describe the often invisible arrangements that make coordinated activity possible. Think of it as like the connective tissue of complex systems. Infrastructure can take material forms, but it can also consist of standards, classifications, protocols, record-keeping systems, and other background mechanisms that allow people, technologies, and institutions to coordinate operation within a shared world. What makes an infrastructure distinctive is that we rarely notice it when it functions well. It recedes into the background, becoming part of the taken for granted environment within which action occurs. We tend to notice it only when it fails, when the light goes out, when records cannot be located, when categories become contested, when standards or rights come into conflict, or when information can no longer move where it needs to go. And seen from this second perspective, many of the recurring concerns in Purna's book take on a different significance. The fixation of a work stabilizes an object across time. Form creates boundaries around that object. Ownership provides a signal that allows others to orient themselves toward it. Rights coordinate the conduct of strangers who may have no relationship to one another. The principle of numerous clauses limits the forms that legally significant interests may take. I could go on forever. Licenses and derivative interests create pathways through which copyrighted works can circulate without losing their identity as legal objects. But what unites all of this is that what appears doctrinally diverse begins to look functionally unified in a brand new way once Purna follows the reclassification of copyright into property and into the systems that govern what it means to own something. The book therefore invites a much broader question that extends beyond copyright. How do legal systems construct the infrastructures necessary for cultural objects to circulate? I mean, creative works don't simply move through markets because they exist. They move because institutions provide mechanisms that make them identifiable, transferable, divisible, enforceable, and knowable across distance. Much as standards allow information to travel across technical systems, legal forms allowed copyrighted works to travel across contractual relationships, industries, and even courts. And this reading also highlights a feature of the book that I found particularly intriguing. Scholars like Jeffrey Bowker and Lee Starr, who I mentioned earlier, and Paul Edwards have all emphasized the analytical value of what Edwards calls infrastructural inversion, bringing into view the background systems that ordinarily disappear from sight. Infrastructure becomes visible when we stop taking circulation for granted and begin asking what makes that circulation possible in the first place. And much of this book, and I know Purna and I come from very different backgrounds, but much of this book can be read as precisely that kind of inversion. Rather than beginning with disputes over infringement of or ownership, Purna repeatedly asks what conditions must exist before such disputes can even occur. Before a work can be infringed, it must be stabilized as an object. Before ownership can be asserted, the object must possess boundaries. Before rights can be transferred, there must be recognizable forms through which transfer can occur. And it is because Purna destabilizes how we conceptualize copyright that she can repeatedly excavate these background conditions and place them at the center of the analysis. And this raises an interesting possibility. The deepest contribution of the book for a scholar with my orientation is not a theory of copyright as property, although that is stunning in its own right. It is the effort to shake loose the conceptual underpinning of the legal infrastructures that make copyright governable and to trace the ramifications of that loosening. And read this way, the book becomes part of a larger conversation about the often invisible mechanisms through which institutions create stable objects capable of moving across markets, organizations, and regimes. Property, in this account, appears less a category than an infrastructure for coordination. But this infrastructural reading brings me to another line of questions. Infrastructure exists to coordinate activity. Roads coordinate movement. Standards coordinate communication. Record-keeping systems coordinate information. The natural question then is what form of coordination are these legal infrastructures designed to achieve? And here I found myself moving from the language of infrastructure to the language of order. It became difficult for me not to notice how frequently Purna's arguments return to problems of order in the face of uncertainty. The infrastructures that she excavates allow strangers to orient themselves to one another and toward the objects around which they interact. And that brings me to my final reading, reading number 3, ordering. Running through the manuscript is a recurring concern with ordering and orientation. How do strangers know what exists? How do they know where its boundaries lie? How do they know what claims others may assert? How do they know what obligations they themselves bear? These questions surface in different doctrinal guises throughout the book. Thinghood, originality, exclusionary rights, derivative interest, notice, infringement, but they point toward a common problem. The problem of creating a world that can be successfully navigated by people who lack complete information. What interested me from an SCS perspective was the consistency with which property appears as a response to that problem. Throughout the manuscript, doctrines, categories, and principles are evaluated in terms of their capacity to create order and make relationships more intelligible. This observation places the book within a much broader intellectual tradition than property alone or law alone. One of the recurring concerns in STS has been the relationship between knowledge and order. Sheila Yasanov's work on co-production, for example, has shown how ways of knowing and ways of governing emerge together. Categories, standards, and institutional practices describe the world, but more importantly, they help create forms of social order by rendering some relationships visible, stabilizing expectations, and establishing procedures through which disputes can be resolved. Knowledge and order are produced in tandem. They are co-produced. That's her idiom for it. And read this way, this third way, Purna's repeated reliance on thinkhood, form, notice, exclusion, and numerous clauses begins to look like a coherent ordering project. Each concept performs similar kinds of functions, reducing the range of possible interpretations, narrowing uncertainty, creating greater predictability in the relationships among authors, users, licensees, assignees, courts, and third parties. And this is perhaps most visible to me in the book's treatment of numerous clauses. Property scholars, and Purna cites several, have discussed the principle in terms of information costs or the limitation of permissible forms of ownership. Yet from this book, I feel like I learned another way of understanding the principle, and it's as an ordering device. Numerous clauses constrains the proliferation of legal forms in order to preserve intelligibility. It seeks to ensure that strangers can encounter a legal relationship and understand, at least in broad outline, what obligations and expectations accompany it. The principle reinforces the order from which it emerged by limiting variation. And we could brainstorm several other examples from the book because it's rich with them. But having offered that one, I'd like to offer some closing thoughts from these readings. I'm still good on time, right, Adam? I think. Okay, yeah. What stayed with me is how well the book supports being read across these registers all at once. Classification, infrastructure, and ordering are overlapping descriptions of the same analytical achievement. The book shows how much work has to be done before copyright can appear as a stable legal object, and how much of that work can become visible when we tinker with our assumptions about the kind of law that it is. That, to me, is the larger significance of this extraordinary book. It invites us to look before doctrine has fully hardened it. It invites us to look before doctrine has fully hardened into doctrine, before infringement, before transfer, before ownership, before remedies, and ask instead, what must already be in place for those questions to become intelligible? What categories have to be available? What background arrangements must hold? And what forms of order make strangers able to navigate that field? Those questions reach well beyond copyright. They are questions about how law makes things governable. Sorry, English is my second language, and my pronunciation of some words changes as I go. Purna's book gives us a wonderfully rich occasion to think about that phenomenon. Thank you very much.
Thank you, Kwan. Fantastic framing and excellent interdisciplinary commentary on a work. So we're moving on now with our third commentator, who is going to be providing, I think, a more legal perspective, Professor Henry Smith from Harvard Law School. So take it away, Henry.
Thank you, Adam. I too am really happy and honored to be here and to talk about this wonderful book by Purna Mysore on copyright as personal property. This really is, as the previous commentators have said, a path-breaking book. It makes many contributions. I'll focus on two contributions, especially one over the other in a moment. But I will say that either of these contributions could sustain an entire book. So I'll try not to go on at too great length. The two contributions are related. The first one is an extended argument that it is wrong to think of intellectual property as a shows in action. Now, this is a little bit more directed to a UK audience. The argument is very convincing, but it is very widespread in the UK and in Commonwealth circles that copyright is intellectual property generally is a shows in action. That, of course, raises the question of what, what actually is a chosen action. And It's basically a right to sue, and there are lots of different definitions. It's kind of pulled in a lot of different directions, partly because it is such a problematic category. In the United States, people hardly talk about shows as an action, and the world hasn't ended. So I think maybe that might be. I'm not endorsing all of the sort of anti-doctrinalism in the United States, but the shows in action might be one of the better things to downplay. It is true that the in the U.S. There isn't much talk of shows as an action. But I will say that there is some resonance with this in a more subtle resonance with this in U.S. law, which is that there is some talk here, particularly in problematic contexts, of people owning rights rather than things. There's this whole question of what is ownership in the first place, very hard to define. And so one standard move when things are difficult to define is to get really abstract because that makes things uh, uh, harder to disprove, and this is no different here. So when it's difficult to say what ownership is, then we say, oh, well, it's ownership of a right, which raises all of the problems that Purna talks about. And this is a debate or a problem that goes way back in all of the jurisdictions we're talking about. And you can see this in Salmond, you can see refutations of it in Gretton and so forth. This is all over the place. And what Purna says here, I think, applies to that debate too, and that's important. But beyond that, in the U.S., there isn't that much, not sufficient attention, I would agree, on the mechanisms by which we achieve our purposes in areas like copyright or private law in general. And that brings me to the second major contribution, which I'm going to focus on more, which is the relationship of copyright to property, the relationship of intangible property to tangible property, which is a huge subject. It gets excellent treatment here. There are a lot of insights, and I want to discuss a few of them and suggest sort of further directions. This is a contribution both in copyright and in property theory by showing some of the similarities, especially similarities, but differences between copyright and property, personal property in particular, but with some view to land law as well. And as Purna said in her opening remarks, contrary to the sort of usual reaction, emphasizing the property similarities actually constrains copyright, prevents overclaiming, sets boundaries in a sense to the owner as well as to duty bearers. So, uh, what's involved in this kind of reorientation? As has been said before, the numerous clauses does feature very centrally in this book, which I can't be against, and that and in actually very subtle and far-reaching ways. So, for example, I think she brings out very well that the numerous clauses, even from various different perspectives, has a sort of unitary purpose. In the Commonwealth, in civil law, there's an emphasis on traditional arguments about the numerous clauses that we don't allow people to bind people without their consent in different unapproved ways. So if I create a new property right and I want to enforce it against people, they had no say in it. And it might be unforeseeable to them. They might be taken by surprise. They didn't consent to it. It's not like in contract. And it's not like, uh, uh, in torts, we have certain ways that the law says you must behave and so forth. And property feeds into torts. And the idea is that, well, you can't just supply your own content and then expect it to be enforced against people generally. There's also the sort of economic view, sort of expressed economically, that Merrill and I developed, that the numerous clauses, these forms present an information problem for people who are, at large in various ways, and that's in some sense an externality. You're imposing costs on people, and it's not being brought home to you. If you think about it, and I think this sort of emerges in Purna's book, these are actually two sides of the same coin, or the same coin looked at from different perspectives, because the essence of an externality is that something is being imposed on somebody without their consent, and you're doing it without it sort of being brought home to you. It's sort of a sort of floating cost and so forth. And this is pervasive in this property theory as applies to copyright, because copyright binds other people in very important ways involving expression and so forth, and can do it at a great distance, unlike the exclusion from a plot of land, or the exclusion from a pen or a car or something like that. Um, okay, so um, uh, in the same vein, I think this was particularly interesting to me because I wasn't as familiar with the English law on this. These so-called Ainsworth criteria. This is the Provincial Bank versus Ainsworth from 1965, in which Lord Wilberforce set out criteria for recognizing new property rights, which is it's rare for the list to be so uh, set out. But here are the criteria. The right has to be definable, identifiable by third parties, capable in the nature of assumption by third parties, which is capable assumption, not necessarily assumable, and have some degree of permanence or stability. And you can see that this idea of uh, sort of ordering the relationship between non-consenting parties, or setting the platform for people to contract consensually, that is emphasized in all these theories of the numerous clauses, both traditional and non-traditional, are implicated in this. So there is this sort of deep theory going on here of how to achieve our purposes at reasonable cost, and I've sort of labeled that an architectural approach. And there's a sense of architecture, sort of private law architecture, that is a thread that goes through this book, and I think. Khan's remarks show that this is, an issue that's not limited to law, but law does have this aspect. In doing this, which was also very interesting to me, and I can't be against, Porner emphasizes the thingness of copyright. Now, this is interesting because even among areas of intellectual property, thingness is not something that necessarily comes immediately to mind when we think about copyright. And this is actually kind of it comes as somewhat counterintuitive, or something that's not generally noticed. So that's already very interesting. It's a very important point. And one of the questions that the book raises is, how much mileage can we get out of the copyright work, to use the English term, as a thing? How much is the expression a thing? And I think Porno definitely shows that it is much more so than is implicit in a lot of the discussion, both in the UK and in the United States. In the UK, partly because of this emphasis, as I said above, about the shows in action, that the only way to enjoy this is to sue, it would be one version. That completely ignores the substance of copyright and how it is implemented through form and so forth. And likewise in the United States, I mean, there's a lot of discussion of, here's the list of rights and so forth. And the idea of this relating to a thing in any sense is not terribly important. I guess I would sort of put on the table a question about whether thingness itself is a matter of degree. So Purna does subscribe to the view, which I agree with, that rivalrousness is a matter of degree. So, for instance, this pen is very rival. I'm using it; nobody else can. But land is less so, because more than one person can be on it and use it in different ways. And information even more so, as is very familiar. And I wonder if the kinds of things we're talking about in intellectual property and copyright in particular is, maybe the idea of thingness is a little more ethereal. Where Purna brings this in is to talk in terms of trespass versus nuisance analogs. So if you think about, for example, Learned Hand's discussion of characters and as characters in a play in the Nichols versus Universal Pictures case, like if you have plays about families and lovers who are, from different communities, Jewish and Irish Catholic, and then you have these two plays. Are these characters copyrightable? You could think of that in terms of nuisance, but Hand himself noticed that this does pressure our whole idea of what a boundary is in copyright. And he said pretty famously that the boundary is it will always be impossible to delineate. And Purna's answer is, well, this is more of a matter of nuisance, and I agree with that. But there's a matter. I'll get back at the end to a little discussion of nuisance. The question there is like, how much work is the thing doing? And that's true in nuisance law. And I think there's interesting questions of like, how much of this is on a spectrum and where it is. So as I said, I agree that there's a spectrum of rivalrousness. She also says there's a spectrum of property, which I agree with as well. How to characterize that spectrum, I think, is interesting, and there could be various versions of it. In the UK, there's much of it more of a tendency to say that something is property or not. It's and of course, if it's tangible, that's going to be the basis of a very stark dichotomy. So this is quite revolutionary in that context. I the In drawing an analogy to tangible personal property, I don't think that Purna is saying that, and she disclaims this, that, well, this is property, that full stop, that's it. It's on that side of the line, end of story. And I think one way of saying this is not the end of the story is to say that there is a lot of territory sort of in between property and contract. Property and contract come together in intellectual property. They come together in bailments and leases and trusts and so forth. And I think there is a big territory here, and a lot of the discussion of the book actually winds up being in that territory. Some of the stuff about, what we should imply into contracts. Is this a temporary right? Is it, what are the consequences and so forth? So I guess I would emphasize the intermediateness of this, which is definitely more than implicit here, but I guess I would emphasize it even more possibly. But maybe we can talk about that. And I also think that the book very helpfully delineates some of the audiences that are relevant here. So there's a distinction between trespassory audiences who might infringe, and there's also the question of does this right run to successors, like in the licensing context, who's bound by the license when there are transfers of interest and so forth. I would say that there's also a question of sort of fuzzying up the nature of these rights in general, so that if we have more extreme versions of idiosyncrasy, might that sort of make it more difficult for people to sort of figure out what a right is in the first place? And Purna mentions this in the connection of whether having a registry would solve all problems, and she says it wouldn't. And I think one of the reasons it wouldn't is that there's still some room for standardization of rights, even if you've got all the data in a registry. So when people use a registry, if they have more of a registry, I guess we have more of a registry here, but what are they looking for? And so there are kind of standardization questions that go beyond that. And in that connection, I think going back to the idea of externality, some of the more far-flung versions of this are really outside of what Merrill and I called the zone of privity. So if you think about people transacting with each other and their successors, in some sense, there's privity there, because I'm using this in a sort of loose way, because the cost of whatever they're doing might be brought home to them. In a transaction, it depends on procedural unconscionability and so forth. And in the successor context, it depends on whether those people, what happens there will sort of be reflected further back up the chain to the transactors. So like if I put a horrible thing as a restriction on property, is that going to lower the price I can command now? Those sorts of questions, I think, sort of remain. I'm getting there. One of the fundamental differences between intellectual property and regular property, as Lauren made mention of, is that we're using structures in a statutory way that are semi-familiar from areas of law that grew organically, and we're applying them in a new context. So, property and torts and conversion and nuisance and so forth grew up uh, in over time in a, if you will, a sort of more organic way than when we're designing an intellectual property system. And the question is, what that means for drawing analogies. Does it point to maybe more intermediate structures, like I mentioned a moment ago? Does it point to sort of a more mix and match treatment of property? So, for example, if we, if you have different kinds of property treatment, trespassery, running to successors, persistence, even in insolvency, and sort of what's part of the patrimony of an owner and so forth. Those could come apart. They sometimes do. And I guess a question for further work would be, given that intellectual property is using these structures in a somewhat more artificial way, does that point to prying apart these notions of property like trespassery and running to successors and persistence and so forth more than we do in regular property, or not? I think I get the sense from the book that the answer is probably yes to some extent, but I'd be interested in hearing more. So just a couple of last thoughts, three very short thoughts. One is sort of questions for further discussion. One is that yes, the copyright is very similar in many ways to tangible property, but it is more of a bundle of rights than, for example, property and land or property and pen, or even a patent. A patent is much more thingy and is much more sort of a sweeping right to exclude than is copyright. On both sides of the Atlantic, you have an enumeration of rights at a pretty high level, but that's not the way that property is generally delineated. This is part of the reason why some people are misled to think of shows as an action. But nonetheless, I agree with Purna's basic analysis of this as property, but it is further along the spectrum towards an articulated bundle of rights than we often see. Second, sort of open-ended question for further discussion is what kind of approach to nuisance is really the best for drawing the analogies? Purna talks about balancing, which is true of nuisance, but you could have a version of balancing like the second restatement of torts back, in the ALI's restatement of second restatement of torts, where it's very balancing oriented, it's very open-ended in terms of factors, or you could have balancing more like English law or traditional American law, or there's still that kind of locality-based version of balancing and so forth, which I guess our new restatement is more subscribing to, and I think that would actually make a difference to how the copyright analogy might be drawn. But I'd be sort of interested in hearing more about that. And finally, at various points in the book, Purna notes that adverse possession, prescription, relativity of title, like different people with different strength of claim, work differently in IP, and that is definitely descriptively true. I think that's also true for deep reasons. I think it would be very difficult for intellectual property to have a notion of adverse possession. And if it tried, it would be very problematic. If somebody starts licensing a work, without permission of the owner and then says, "Wow, I'm the owner of the copyright," that's problematic. It's problematic for all sorts of expression reasons, free speech reasons, and so forth. It could be unfair surprise. It's a different kind of property, and so forth. I would say in this context that I subscribe more to the sort of clearing titles version of adverse possession, rather than, as Purna in the book says, the lazy owner theory, which is also a traditional theory of adverse possession. But the reason I bring this up is that in doing the restatement, the question we get asked, maybe almost more than any other, is, are intangibles property? Okay, so that's kind of at an unhelpful level of generalization. But what's concretely really to the fore is, can intangibles be converted? And that is highly related to the question of adverse possession. And I think the idea is that if we're too permissive about applying notions of conversion and possession, and we might start seeing notions of adverse possession and unfair surprise and all sorts of intellectual property by the back door, as it were, through the law of intangibles. And I think one interesting implication of this book would be to ask, okay, now that we see how the analogy runs out in areas like adverse possession, what does that tell us about what the limit should be on property and intangibles, where this problem is kind of new and unexplored and still a work in progress. So this is a terrific work, and it's terrific both for the problems it solves and the problems that it points to that will be solved in the next book. So thank you very much.
Thank you, Henry. And thank you for giving us a beautiful visualization on your desk behind you of the numerous clauses rule of having your fixed categories of stacks. I like that.
That's a kind interpretation.
So that thank you to all of our commentators for providing just an incredibly deep, rich, and breadth of interdisciplinary feedback and reactions to Morna's very as I said, equally rich and robust monograph on property theory and intellectual property with copyright specifically in here. Thank you again. Great commentary. Fantastic book.